Hello, I'm Daniel, the Arizona Supreme Court's AI Court News reporter. I'm here to report on an opinion issued by the court today, using a script drafted by the justices. The Arizona Supreme Court has ruled that prosecutors may refile criminal charges against defendants who were previously found not competent to stand trial and not restorable, also known as NCNR. Prosecutors must only show they have a reasonable belief that a defendant's mental condition may have improved, making them competent to stand trial and do not require court approval to do so. This is a lower standard than rebutting the presumption that the defendant is incompetent. The court also decided that ARS Statutes 13-4517A4, which allows prosecutors to ask for a dangerousness trial, can be applied even to cases that began before the law was enacted. In a dangerousness trial, prosecutors must establish that the defendant committed the crime charged and must prove beyond a reasonable doubt that an NCNR defendant is dangerous and should be involuntarily committed until they either regain competency or are no longer a threat. The case leading to this decision involved Joel Carson, who was charged with murder in 2018. In 2022, a trial court found him NCNR and dismissed the charges. After his release from a mental health facility, the state refiled charges, believing his condition may have improved. Carson argued that court approval was required to refile, citing an earlier appellate ruling. After multiple dismissals and appeals, the Supreme Court stepped in to clarify the rules. Writing for a unanimous court, Vice Chief Justice John R. Lopez IV explained that prosecutors, not judges, have the authority to decide whether to refile charges. Requiring court approval would improperly place the judiciary in a role that belongs to the executive branch. The key takeaway is that the court's decision sets clear standards for prosecutors, allowing them to refile charges when they reasonably believe a defendant's competency may have changed, and they may also seek dangerousness trials even if the NCNR ruling happened before the statute was passed. To read the news release, visit azcourts.gov. Thanks for watching, and follow us for more updates on important court information.